Hi, this is the Business Guy. So how do you protect yourself from lawsuits? To protect what you have, it is essential to take some measures to make it more difficult for creditors to take your assets away from you if you lose a lawsuit, have a judgment filed against you, or are forced into bankruptcy. I'm the CEO of Lawyers Limited and Asset Protection Planners. We have attorneys on staff, and we're the nation's leading asset protection firm. And today we're going to talk about the 8 best ways to protect your assets from lawsuits. And if you're ready to take action or have questions, feel free to give us a call or fill out our free consultation form on our website. The first way to protect yourself from lawsuits is to set up business entities. It is important to separate your personal assets from those of your business. And if you neglect to take specific legal steps to create a business entity, such as a corporation or a limited liability company, LLC, a simple business dispute could well cost you nearly everything you own. Now, there are a number of business entities to consider and some not to consider. Sole proprietorships. Sole proprietorships offer no limit on personal liability. One mistake could cost you your home, depending on your state, your car, your bank account, and much more. General partnerships. General partnerships are the worst of all. If your business partner creates a business liability that has nothing to do with you, and he or she loses the lawsuit, you are joined at the hip. Technically, lawyers could come after you because of your partner's actions. And even if it's not a business lawsuit, the judgment can take the business away from both you and your partner. And one thing that's totally safe, if you partner with me and click the like button so YouTube promotes this video, I'd really appreciate it. Thanks so much. And if you haven't already, you can also click the subscribe button below so that when more videos come out like this one, you'll be up to date right away. Corporations. Corporations provide excellent lawsuit protection for their owners when somebody sues the business, with the exception of fraud or you failing to pay payroll taxes to the IRS, or if you don't treat the corporation as a separate entity from yourself. Your personal assets cannot be confiscated in the event that your business loses a lawsuit. The issue with corporations comes when somebody sues the owner personally. In that case, the owner's creditors could take the owner's stock in the corporation. Now, there are 2 kinds of taxation for for-profit corporation, the S corporation and C corporation. Now, they are taxed differently and have different restrictions on ownership, but both provide similar lawsuit protection for their owners. Limited liability companies. LLCs provide legal protection against business lawsuits for the owners, but with fewer restrictions on ownership than corporations. They also allow their owners to choose whether to file federal taxes as a sole proprietorship, partnership, C corporation, or S corporation. Now, how your LLC is taxed has little to no bearing on how it protects you from lawsuits. Now, there's one major advantage in some jurisdictions that LLCs have, and that's charging order protection. On one hand, if a corporate shareholder loses a lawsuit, a judgment could award a number of shares of stock in the business to the creditor. That gives them access to your books and records and could give them control or ownership of your corporation. With an LLC, on the other hand, even if a plaintiff gets a charging order, he cannot force the distribution of cash, but he is still taxed whether he receives the cash or not. So that poison pill can help you prevent a lawsuit or settle in favorable terms. Strategy number 2 is an asset protection trust. Now, this is considered the most powerful tool to protect money from lawsuits. The best asset protection trusts are formed offshore. How do they work? Local courts do not have jurisdiction over our foreign law firm that serves as the trustee. It ties the hands of the courts and the opponent's attorney. Now, there are domestic asset protection trust options, but the case law does not look very good for them. We've seen them penetrated over and over again by results-oriented judges. So the strongest legal statutes are in the Cook Islands and Nevis. In fact, the offshore trust is one of the few asset protection strategies that can work after a lawsuit is filed. We almost always put an offshore LLC inside of the trust. The LLC holds the bank accounts, and that way you can serve as the LLC manager and account signatory until you need our international law firm to step in and protect you. Suppose a judge orders you to turn over the money, so our law firm can legally refuse to comply. This strategy works best for liquid assets that you hold safely in an international institution. In fact, we've set up more offshore trusts than any firm in the nation. We know of no client who has lost money using one of these structures that we have established. Number 4, homestead exemptions. Some states provide a lot of protection to home equity, which means that when you get a judgment against you, The law prohibits courts from awarding home equity to creditors. In some states, including Texas and Florida, state law protects an unlimited amount of home equity. Other states provide relatively little protection to home equity, and some states, such as New Jersey and Pennsylvania, have no homestead protection at all. So check your state laws, and if your state provides a generous homestead exemption, consider contributing extra principal to mortgage payments to protect those funds. Now, principal contributions to your home are subject to the whims of the housing market, so they are subject to risk in that you will lose access to both the equity and the cash if the property falls in value. Alternatively, if your state provides minimal homestead protection, accelerating mortgage payments or paying down principal may not make sense if you're looking to protect assets from creditors. So what we do is we use equity stripping strategies to protect real estate equity. We record liens on the property that can be eventually purchased by our offshore lender and then distribute it into a you can't touch it account within your offshore trust. Number 5, titling. Examine how your home is titled. If you own your home with your spouse as tenancy by the entireties, which is available in just a few states, both you and your spouse own an indivisible interest in the home. If only one of you is named in a suit, creditors cannot force the other spouse to sell his or her interest in the house. Because the interest is indivisible, this can help you protect home equity where the state law doesn't provide a sufficient homestead exemption. And again, this option is only available in some states, and in some states, it may only apply to your personal residence, not investment property. Other forms of titling include tenancy in common, joint tenants with rights of survivorship, and the way you have property titled can have profound ramifications in the event that a creditor makes an attempt to seize the asset. Make sure to speak to a lawyer in your state for specifics on any of the things in this video concerning your situation. Number 6, annuities and life insurance. Some states provide significant protection to annuity balances and to assets and cash value life insurance policies. For instance, Florida provides unlimited protection for these assets, while Oregon provides protection for up to $500 per month in annual income. Now, each state has its own laws, so check with an attorney licensed in your state for specific exemptions. Number 7, get rid of it. Creditors cannot seize assets that you no longer own. Therefore, consider transferring ownership to offshore trusts from which you and your family members can draw income. If you're in a high-risk profession, consider transferring assets to your asset protection trust early. Now, you can still use the money while you're alive, and afterwards, there are estate planning provisions so that your family can benefit and enjoy the inheritance. Don't just transfer to family members directly. The courts will accuse you of fraudulent transfer and sue your family members. Plus, you must assume that whatever you give to somebody else, even a spouse or your favorite child, is gone for good. A carefully crafted trust is the best solution when it comes to giving away your wealth. Number 8, don't wait to protect yourself. Now, it's best not to wait until a lawsuit is imminent before you make these moves. And if you do, the courts could rule that your transfer of funds into a protected class is a fraudulent conveyance and disallow the transfer, leaving those assets exposed. In that case, the Offshore Asset Protection Trust may be one of your only options. And above all, don't become a tempting target and avoid displays of conspicuous consumption. This could attract trial lawyers and cause them to take a plaintiff's case where they would otherwise pass on it. So don't flash the cash unless you want to crash. And keep in mind that a law firm has just as much sympathy for you as a pack of lions has for a baby gazelle. Hey, you're just their next meal. So if you're serious about protecting yourself from lawsuits, give us a call at 1-954-400-1050 or fill out our free consultation form at assetprotectionplanners.com. See you next time. This is The Business Guy.